delay. I think we're good. All right. Oh, good. All right. I will call the meeting to order at 10:04. The first thing we will start with is, and really quickly, I apologize. Chair Clements had a family emergency and is unable to be here today, so I will be filling in as the chair for this meeting. For anybody that doesn't know me, Justin Stedman from Fish and Wildlife, one of the vice chairs. Lindsay, would you be so kind as to do a roll call vote, please? Roll call vote, please.
Yes, I will do roll call. If you could turn on your cameras and say whether you are present, and I will go through each council voting member's name. Leslie Johnson. Here. Butch Shaw,
Yes.
Wade Cochran,
Present.
Justin Stedman,
Here.
Heather Sinkowitz,
Here.
Domenica Padula,
Here.
Kim McManus. You may not be on yet. Okay. Aaron Hodges. Here. Tom Jeanette.
Here.
Mark Anderson,
Present.
Jonathan Bixby,
Here.
Kate Peralta-Kavam. Sorry if I butchered your name. Kate, I see you on camera. Can you hear me? Kate Peralta-Kavam. Can you hear me? I don't think she can hear me. Let me see if I can ping her. I will come back to Kate, but just continuing on for non-voting for the purposes of this hearing. So those were all the members that were present for the last hearing and heard all the evidence. But for other council members, David Peterson,
Present.
James Pompriand, Daniel Guerra,
Here.
Glenn Boyd,
Here.
Sean Pratt. He just came on. Oh, and I will go back just for a couple people. Kim McManus.
I'm present.
Stop.
Thank you.
And Kate Peralta-Kavam. Can you hear me? Okay, I'm gonna just try to email for the purposes of having her say whether or not she's present. I will email her.
And so we have quorum to start the meeting, Lindsay.
Correct, we do have quorum to start the meeting.
Perfect, thank you. All right. So first order of business, are there any additions or deletions to the agenda? All right, seeing none, then the next order of business will be to continue docket number 20246, D as in David, 9 R as in Robert. We have, unless I am misinformed, I believe we are going to hear closing arguments from Attorney Milligan and Attorney Perquette. Is there anything else from either attorney that do we need to deal with, or do we move straight into closing argument?
Mr. Chair, I just think procedurally I should inform you that I'm resting without presenting evidence.
Thank you very much. I appreciate that. But Mr. Perquette, or Attorney Perquette, I saw your hand up and then down. Is there?
Mr. Milligan took care of the procedural matter. I was going to bring the attention, the same thing he just did.
Perfect, thank you. I appreciate that. Well, with that, then I would turn to
This whole time.
oh, sorry, somebody said something. Or maybe that was just for everybody on the call. If you are on here, please mute your mic unless you're talking so that we don't have any issues. Not right. So I believe then Attorney Perquette, I would turn the floor over to you.
Very good. Thank you, Chair, and good morning to the council. Can you see my, what I'm sharing on screen?
Yes.
Yes.
Excellent. Then with that, I will begin. It should not have even happened, is what Lieutenant Ackerland testified to. It was a lot for a jaywalking incident, you know, is what Chief Pierce said. And he was right, it was. From this pretext stop, George Johnson threw a man, John Stezel, someone he did not know, to the ground. He threatened him, he swore at him, he told him he was being detained, then told him he was being under arrest. He tried to grab his hands, his body, his hoodie. He ordered him onto his stomach to give over his hands for handcuffing. He sprayed him with OC spray. He lost control of his taser, but when he regained it a second later, he himself switched off the safety, and without any further warning, he shot Mr. Stezel in the chest, causing pain. He moved in to press the taser against Mr. Stezel's skin, prompting another scramble for the weapon that saw Mr. Johnson get tased with his own taser. But seconds later, when he was back on his feet, back in possession of his taser again, while John Stezel lay prone on the ground with his hands open and empty, he ordered his backup, his subordinate, McKendrick Johnson, to shoot John Stezel with his taser, with anger in his voice, saying, "Hit him with it. Hit him with it. He already tased me." He didn't wait to see what the result of this taser shot was. Instead, he turned his taser around in his hand. He adjusted his posture. He adjusted Mr. Stezel on the ground, and then he swung his taser like a club and slammed it against John Stezel's face, fracturing his bones. He punched Mr. Stezel in the back of the head and back 4 times, bouncing the man's face off the pavement, then finally pressed his taser into the base of the man's spine and pulled the trigger one last time, causing pain. All of this from a stop that started with a conversation about jaywalking. The Professional Regulation Subcommittee has charged Mr. Johnson with committing Category A and B unprofessional conduct. Let me define these categories for you. Category A conduct is when an officer commits either a felony or a misdemeanor that is committed while on duty and did not involve the legitimate performance of duty. Category B conduct, as it relates to this case, deals with excessive force. It is defined as gross professional misconduct amounting to actions on duty or under authority of the state or both that involve a willful failure to comply with state-required policy or substantial deviation from professional conduct as defined by the law enforcement agency's policy, or if not defined by that policy, then as defined by council policy and will include excessive use of force. The felony that the Professional Regulation Subcommittee has determined that George Johnson committed is aggravated assault. Aggravated assault can be committed in 2 ways. First, with a deadly weapon, where the elements of the crime are that George Johnson knowingly caused bodily injury to John Stezel by use of deadly weapon, or by causing serious bodily injury, where the elements are that George Johnson knowingly caused bodily injury to John Stezel. The misdemeanor alleged by the Professional Regulation Subcommittee is simple assault, and the elements are that George Johnson knowingly caused bodily injury to John Stezel. This is essentially a lesser included offense to the aggravated assault, as it comes from the same incident and the same encounter. Let's talk about some of the legal definitions in the elements that you just heard about. The term bodily injury, as defined by the law, means any physical pain, illness, or any impairment of physical condition. The term serious bodily injury means bodily injury that creates substantial risk of death or which causes substantial loss or impairment of the function of any bodily member or organ, or substantial impairment of health or substantial disfigurement. The term deadly weapon means any firearm or other weapon, device, instrument, material, or substance, which in the manner in which it is used or intended to be used is known to be capable of producing death or serious bodily injury. Finally, the term knowingly means to be aware that the conduct could cause or is practically certain to cause the harm. In other words, not an accident, not something that is inadvertent. The council shall find unprofessional conduct if the facts demonstrate by a preponderance of evidence that Mr. Johnson committed either Category A or Category B conduct, or if it determines both. Preponderance of evidence has often been talked about as 51, the greater weight of the evidence, 51%. And this is different than in a criminal trial where the burden of proof is proof beyond a reasonable doubt. And if you need to think about the difference between the two, think about O.J. Simpson. O.J. Simpson was acquitted of the crime of murdering his spouse, Nicole Brown Simpson. However, he was found liable for the civil wrong of wrongful death, the civil tort of killing his spouse, Nicole Brown Simpson. That shows that the same facts can have different outcomes based on different standards of proof. Did George Johnson commit aggravated assault? Yes. How do we know this? Because George Johnson admitted it to us. In his testimony, he admitted he caused bodily injury when he struck Mr. Stezel in the face with his taser. In fact, he admitted he caused him serious bodily injury by causing bone fractures. And as you can see in the trailhead camera, he struck the man so hard his head bounced off the pavement. We also have the medical records of Mr. Stezel where the doctors in them wrote, quote, "You have multiple facial fractures and need to follow up urgently with Dartmouth Plastic Surgery Clinic." He admitted that he held his taser so that he could use it as a blunt instrument, as an impact weapon. This was not, therefore, an inadvertent or reactive thing. This was his intent. In fact, he admitted to Detective Sergeant Baker that it was his intention to strike him, to daze him with this blow. That's what he told the detective sergeant. And finally, he admitted that the taser weapon is in fact a deadly weapon. So, looking back at the elements of the crime of felony of aggravated assault with deadly weapon, George Johnson clearly knowingly caused bodily injury to John Stezel by use of a deadly weapon. Aggravated assault by serious bodily injury, George Johnson knowingly caused serious bodily injury to John Stezel. How else do we know that he committed this category A unprofessional conduct by committing a felony? Well, because there was a criminal investigation that was initiated by Mr. Johnson's own chief, Chief Pierce. Detective Sergeant Angela Baker of the Vermont State Police conducted the criminal investigation. She spoke to every police officer who went to the scene and every eyewitness. She interviewed every person who came forward with information about the incident, whether that information helped or hurt the investigation one way or the other. She simply was a neutral collector of information. She walked the scene. She collected photographs from St. Johnsbury Police Department, from the Caledonia Record reporter who came to the scene, and from George Johnson himself, everything that he asked her to consider. She reviewed the body-worn camera footage and the CCTV footage that we have seen. And finally, she interviewed George Johnson. And at the beginning of her interview, she explained her role there is to be an objective fact finder, just to collect information. She did this at a time that was convenient for Mr. Johnson. She did it at a neutral location. She did not ambush him. She interviewed him at a time when his lawyer was present. She let him explain without interruption. She made it clear that what she really wanted was as much detail as possible, and she took breaks as he needed. As she said, there was no time limit for this interview. This was his time, and she wanted him to have as much time to provide as much detail about what happened as possible, because her job at that point was simply to get the facts. The result of her investigation was, after reviewing all of that evidence, all of those photographs, all of those statements, all of that testimony, she determined she had probable cause to charge him with aggravated assault. So she drafted an affidavit of probable cause, which is the affidavit that initiates a criminal charge, one that was 10 pages long. You have it in evidence as Exhibit 10, and this was provided to the prosecutor and ultimately to the court. She also created an investigative narrative, 34 pages long. This is Exhibit 11, also in evidence before you. This is not provided to the court. The difference is a PC affidavit is a summary of facts necessary to charge the offense. It does not include everything that an officer sees, doesn't include all of the evidence they collect, all the photographs that they observe, all of the records that they look at. That's what the narrative, that's what the investigative narrative is, which you also have in evidence. Her affidavit was then sent to a seasoned prosecutor for their independent review, meaning that Detective Sergeant Baker was not the end decider as to whether or not George Johnson commit aggravated assault. But the prosecutor also found that the evidence was sufficient to file the charge in court and filed the charge of aggravated assault. That's Exhibit 20. And then a judge then independently reviewed the charge, meaning the affidavit of probable cause and the charge for probable cause, and again found probable cause to let the charge go forward. But the case was dismissed. Judge Kanan, who had found probable cause on Mr. Johnson's own motion, then reconsidered and found that there wasn't. His reason, George Johnson was a police officer. As such, he was entitled by statute to use reasonable force. Michael Kanan concluded that Detective Sergeant Baker's affidavit did not demonstrate the use of force was unreasonable to the probable cause standard. And here's the quote from his own order. After reviewing the evidence and considering law enforcement officers' statutory privilege to use reasonable force, the court concludes that Detective Sergeant Baker's affidavit does not contain sufficient information for the court to find probable cause that Sergeant Johnson committed a crime. In other words, the probable cause affidavit was missing facts that would let the court see the excessive nature of the force. This was not a determination that George Johnson had done the right thing, merely that the document presented to the court failed to demonstrate beyond a reasonable doubt that he did the wrong thing. So why should we have a different result here? Well, first of all, legally, we have a different standard of proof. As discussed before, criminal cases must be proven beyond a reasonable doubt. It's the highest burden of proof in our system of jurisprudence. Our burden at counsel is lower, preponderance of the evidence. That's a significant difference. Moreover, in criminal court, Mr. Johnson had the benefit of the presumption of innocence, the same as any person accused of a crime. That means if there is no evidence, no documents, no testimony, or whatever on any particular issue or any particular element, that presumption says the defendant receives the benefit. In other words, if there is no evidence whatsoever, we have to presume that that element goes to the defendant. He wins all ties. Factually, the judge never heard from a use of force expert at all. How do we know that? Because George Johnson told us that. Why is this important? For the same reason you go see a doctor when you're looking for a medical diagnosis because something's wrong with you. An expert can provide you with valuable opinions and conclusions based on their specialized knowledge, skills, and training, especially when considering a topic most people are unfamiliar with, like use of force. Judge Kanan did not have the benefit of a use of force expert on the issue of use of force, but we do. Lieutenant Michael Ackerland of the Colchester Police. It's worth going through Lieutenant Ackerland's bona fides just a little bit. First is that he's been a police officer since 1997. He's been a use of force instructor since the year 2000, or 26 years. And it's worth remembering that to become a use of force instructor, it's not an online course. It's not a weekend class. This is an intense 40-hour program, after which there is a test for which he has to receive an 80 or above. So a C+ is a failure. And that's on the written portion. On the techniques and on the scenarios portion, it has to be letter perfect. He has to get 100%. He did that in 2000 to become a use of force instructor. He's been a regular instructor in use of force at the Vermont Police Academy since 2009. And in 2017, he became a master instructor in the use of force. And remember his testimony as to how difficult that was. First, he had to have a certain amount of time at various different levels beneath that, being a use of force instructor. He had to teach use of force instruction a number of times. And then he had to be interviewed by a national group of master instructors just to see if he could then take the intensive course to become a master instructor. After passing through that interview, he did, again, an intense course of programming, and again had to receive an 80% or better on the written and 100% in his scenarios and techniques. Again, he had to demonstrate perfection there. This is the PhD of use of force. He's also a conducted electrical weapons or a taser trainer. He's also the ground fighting instructor here at Vermont Police Academy, or I should say one of the ground fighting instructors at the Vermont Police Academy. And as will become relevant later, he's also a black belt in Kempo Jiu-Jitsu. This is the guy who knows use of force. He talked to us about how he reviewed George Johnson's case here. He started with George Johnson's own reports, his probable cause affidavit, his use of force narrative. He then read his interview with Detective Sergeant Baker, including all of the excuses, explanations, and justifications he gave for the uses of force that he did in his encounter with John Stezzle. He reviewed all documents first before he watched a single video, and he told us why. He said he liked to see it first, see the story, see the information as the facts as they're laid out, and then see if it matches up to the video. In other words, he wanted to see the context and understand what the perspective was of the people that was going on before he watched a video, which can be highly colorable in how you see things. But the bottom line is he reviewed everything that we have seen. What were his conclusions? As I stated in the beginning of this presentation, his initial impression was beyond the initial contact with Mr. Stezzle on the bridge, the rest of it shouldn't have even happened. His conclusion was this was a simple field contact, understandably, probably more a pretext stop, but simply for a jaywalking offense, a civil traffic violation, it shouldn't have gone beyond that type of interaction. What is Lieutenant Ackerman saying when he says this? He's saying that George Johnson had a hunch, and he acted on that hunch. As Lieutenant Ackerman testified, both in direct and then under questioning by Mr. Milligan, there is nothing improper with acting on a hunch and making a field contact with someone. This is a voluntary interaction with someone where you walk up and you ask them some questions. And Lieutenant Ackerman was clear. That was what he observed George Johnson doing at the start of this encounter with John Stezzle, when he's in the car, when he's asking his name, when he's pointing out the whole thing with the crosswalk. And he said, there's nothing about that that's wrong. But then George Johnson escalated to physical force. And his conclusion was that the force used after the initial contact with Mr. Stezzle was not reasonable. He bases this on use of force policy. There is a statewide model policy that is effective on all law enforcement officers. St. Johnsbury Police Department has a policy that mirrors this, that all St. Johnsbury police have to follow, even as they have to follow this statewide model policy. And it says that in determining whether a particular use of force is objectively reasonable, the officer must consider the seriousness of the offense the officer believes the subject was involved in, whether or not the subject poses an immediate physical threat to the officer or others, the degree of that threat, whether the subject is actively resisting or attempting to evade arrest or detention by flight, and whether the totality of the circumstances justifies the officer's response. And in analyzing this, Lieutenant Ackerland said as follows. The first and most important is the seriousness of the offense the officer believes involved in. And the answer is the offense here was maybe a civil ticket with a waiver fine of $59. I say maybe because there is a serious question whether Mr. Johnson even had probable cause to issue this ticket. While George Johnson may have had some inkling that John Stezzle was involved in some kind of criminal activity over and above this, based on the location, based on how he was dressed, based on how he was acting, the only concrete offense he can point to when he first uses physical force against John Stezzle and attempts to detain him is this ticket. A ticket that both Chief Pierce and Captain Gray in their interviews with Detective Sergeant Baker said they wouldn't have even gotten out of the car, much less detained someone to give. As far as whether he posed any immediate threat, the answer is John Stezzle posed no immediate threat. Not when he was running away, not when he was prone on his back with his hands open and empty. If he posed any threat at all, and I suggest to you he does not, then the level of threat is minimal. Again, John Stezzle, after being thrown to the ground by George Johnson, is on his back and on the ground. His hands are open and empty. He's not reaching for Johnson, but pushing away Johnson's hands, and Johnson grabs for him again and again. He's calling and shouting for help. He's not making threats. The person who's making threats in this situation is George Johnson. So the next factor is whether he was actively resisting or trying to evade detention. And here's the answer is yes. John Stezzle was actively resisting being grabbed. Yes, he did try and run away. However, given what George Johnson was doing and how he was acting and what he was saying, his actions would appear to be reasonable for someone who had been thrown to the ground and was being told that he was being detained and arrested for no reason and with no reason being given. Which leads to the final conclusion by Lieutenant Ackerland that the totality of the circumstances do not justify the officer's response. This was excessive force. Use of force policy also talks about de-escalation. When possible, officers shall use de-escalation tactics. The shall means this is not discretionary, it's mandatory. Officers are required, not suggested, to try and calm a situation down to avoid the need to use force at all and an attempt to use less force in order to achieve law enforcement objectives. This commitment to de-escalation means that officers should not knowingly create exigency or take actions that may increase the likelihood of force becoming necessary. Did George Johnson de-escalate? No, he did not. Instead, he did the thing that policies expressly forbids, knowingly creating exigency and taking actions that actually increase the likelihood of force becoming necessary. After taking John Stezel to the ground, John Stezel was on his back and cornered. He had buildings on three sides. He was weaponless. He's not going anywhere. At this point, George Johnson is on his feet. He has all of his tools and weapons on his belt and available to him. This is a perfect opportunity that he had to calm the situation down, to attempt to de-escalate. And again, the policy requires, whenever feasible, officers shall allow individuals reasonable time to submit to arrest or detention before any force is used. But that's not what George Johnson did. He chose not to try. Instead, he immediately went in and physically attacked John Stezel, grabbing at him and attempting to physically manhandle him. This is not the only time in this encounter that George Johnson failed to de-escalate. It's just the first time. During the encounter, there were several opportunities to de-escalate that George Johnson chose not to even attempt. He had time enough to call for backup, but he failed to wait the less than 2 minutes before his backup arrived. Instead, after calling for backup, he bizarrely let his radio drop and then later claimed in interviews and during this hearing that he could no longer communicate with his fellow officers, heightening his justification for force by creating a more dangerous situation. But the more dangerous situation was again created by George Johnson. He took actions that increased the likelihood of force becoming necessary. At hearing, he even talked about the dangling radio perhaps being used as a choking implement. He was the one who put that in play. At hearing, George Johnson claimed that he saw John Stezel do something to his radio, but he did not include this in his use of force narrative or in his probable cause affidavit, both of which are before you in evidence. And I remind you, a use of force narrative is designed to identify each use of force that an officer performs in any encounter with a subject, as well as all factors that explain and justify the uses of force that an officer does. This is an important document because it is the document that justifies each use of force that an officer does. And at the time that he fills this out, George Johnson is not just any officer. I remind you that he himself was the use of force trainer for his department, meaning that he had gotten additional information and additional education on the importance of this document. If anyone should know how thorough you need to be in this use of force report, it would be someone like George Johnson. And yet in his use of force report, he puts nothing about this attempt to do something to the radio. The first time he says anything about this is after he's been suspended and he's sitting next to a lawyer. So what does he do instead? He immediately threatens John Stezel and swears at him. The first words he says to John Stezel after taking him to the ground, "Don't fucking move. You're going to get tased." He tells him he's being detained and then under arrest, but never explains why he's being detained, why he's being arrested. He sprays him with OC spray. He tases him in the chest, and when he goes to drive Stensel with the taser, he moves in again. He orders McKendrick Johnson to tase John Stensel. He strikes him in the face with his taser. He punches him twice in the back of the head, hard enough that his face bounces off the pavement. He punches him twice in the back, and then he tases him a final time. Did George Johnson fail to comply with the use of force policy? According to our use of force expert, yes. He failed to attempt to de-escalate despite clear opportunities to do so. He failed to give John Stensel reasonable time to submit to detention before even beginning to use physical force, instead jumping immediately to using physical force. He failed to reassess the totality of the circumstances in his encounter to determine whether force still needed to be used and what level of force is necessary. And again, I quote the policy. Officers must constantly reassess the totality of circumstances in any encounter where force is necessary to gain compliance with an individual. Despite his assurances throughout his testimony that he was constantly reassessing, it was clear from what he did, his actions, that he did not, and therefore failed to comply with the use of policy in his encounter with John Stensel. The expert opinion of Lieutenant Ackerland, who reviewed each use of force action separately, the initial takedown, the spraying with OC, the first shot with a taser, the clubbing of Mr. Stensel in the face with a taser as an impact weapon, the punches to the back of the head, the punches to the back, and even the final taser drive stun. He reviewed each of these separately, and for each of them, he concluded that Johnson used excessive force. Actually, I have to apologize. That's not completely true. He did find one thing that Johnson did right. He noted Johnson's placement of his knee on the shoulder blade after he had him in handcuffs, prone on the ground, and in leg irons, was a reasonable use of force and was following his training. Despite it looking bad to me, so much so that I showed you a photograph of it, which is also in evidence, Lieutenant Ackerman was clear in his testimony that Mr. Johnson actually followed proper training and procedure in his knee placement. He testified that the snapshot was misleading, as photos often can be, and that by watching the entirety of the video and using his own experience, skills, and specialized training, he saw proper technique, and therefore, taken in a vacuum, he concluded that this sole action by Mr. Johnson was a reasonable use of force. Let's talk about the assault with the taser weapon. First, let's get to the conclusion, which is, again, that George Johnson used excessive force. He failed to reassess. At the time the strike happens, there is another officer on scene with Kendrick Johnson. The subject is prone. The subject has no weapon in his hand or in his possession that can be observed. This is an opportunity to de-escalate, and he failed to attempt to de-escalate. He prepped for the strike, meaning he had sufficient time to assess, reassess, and de-escalate. And instead, he changed his grip, readied, wound up for the strike, even positioned himself and Mr. Stensel on the ground, demonstrating his intent was to strike him in the head. Then he hit him with the taser in the temple. Hopefully I can do this. I'd like to show you that one last time, if I can. Because here we see he changes his grip. Sorry. He changes his grip. He takes hold of Mr. Stensel. He moves into his position. He gets ready. He strikes him. But watch where the taser goes. Watch where he puts Mr. Stensel in relation to his taser. This slide is in evidence as part of the use of force training all officers receive. This explains that there are risk areas where striking someone with an impact weapon is not just actively discouraged, it is downright prohibited. And that's because striking someone in these areas has a high risk of permanent injury or death. And two that I've highlighted are the eyes and the temple. We even have a chart about where you can strike with an impact weapon. Why use this chart? Because that's how the taser was used. It was used like a baton. Now, this is a permissible use under use of force policy, if done correctly. So using the taser as a makeshift baton wasn't the problem. It was the fact that he had opportunity to strike elsewhere, the fact that he had an opportunity to de-escalate, and that he failed to reassess. The strike itself, the use of the taser as a baton in an exigent circumstance is acceptable under the policy, but only if it otherwise follows baton policy. And here it did not. Instead, he struck him right here at or above the eye. And if you'll remember from the slide before, that's a red area. This is where he's been trained not to strike. And again, I remind you, George Johnson is the use of force trainer for his department. He's supposed to know where and how and when to use force because he trains others on the when and how and where to use force. He cannot claim ignorance. At hearing, he claimed that he struck John Stezel in the head because Stezel was reaching or grabbing hold of his leg. The body-worn video of McKendrick Johnson demonstrates this to be a falsehood. Moreover, he never mentions this in his use of force narrative, never mentions this in his interview with Detective Sergeant Baker, despite having an attorney present and being encouraged to explain himself without interruption. It is only 2 years and 2 attorneys later that he comes up with this leg-grabbing defense. Why? Because if he's reacting to assaultive behavior from Stezel, that sounds better than unprovoked assault with a deadly weapon. But let's assume it's true, just for a second. Let's give him the benefit of the doubt. And Stezel was grabbing at Judge Johnson's leg. We asked Lieutenant Ackerland if that would change his conclusion regarding excessive force. Lieutenant Ackerland still concluded this would be excessive force, because if the objective of the strike was to free the leg from a subject grabbing at him, he could have struck at the hands of a subject just as effectively, and that this was a green area, meaning less likely to cause permanent injury. Given the fact that this was an intentional strike that he wound up for, it was clearly excessive force. What is Johnson's justification for assaulting John Stezel? Well, he'd just been tased, which is true. He'd been disarmed of his taser, which is also accurate. These justifications point to a reasonable fear of harm by Stezel. After all, at the beginning of his presentation in this hearing, he showed you that misleading photo of John Stezel standing above him, holding the taser by the barrel as proof positive that his fear of harm at being attacked by Stezel in the next moment was objectively reasonable. However, he threw his own OC spray can away, and he put down the taser after the strike. Where did he put it? Right next to John Stezel. And then he rolled John Stezel nearly on top of it. If the concern was that John Stezel would have or obtain a weapon, that concern stopped being reasonable when he made his own weapon so accessible. Again, he's creating the emergency he's using to justify his reaction. That said, he pointed out that when a person is disarmed or when a person uses force against an officer, assaultive behavior, the use of force dashboard turns red. And that, as a result, he could use impact weapon strikes and claimed that he even could have used deadly force at that point. Does that excuse have merit? According to our use of force expert, Lieutenant Ackerland, no. Why not? Again, we go back to policy. Officers must constantly reassess the totality of the circumstances in any encounter where use of force is necessary to gain compliance from an individual. While the level of threat may have been high when he was disarmed and he was on his back, at the time of the strike, he had regained his feet, regained control of his taser. There was another officer on the scene with a taser drawn, and Mr. Stezel was once again prone and weaponless. At this point, reassessing, the level of resistance had gone. This changed the totality of the circumstances. It brought down the level of threat, according to the use of force dashboard. So again, from policy, If the level of resistance offered by the subject goes down, so should the officer's response. I've mentioned the use of force dashboard, and we've seen it throughout this hearing. Here it is. So hopefully you can all see my little pointer here. As he's describing, at the time that he was tased, at the time he falls to the ground, at the time that he's been disarmed, all of these place him here in red, disarming, that kind of assault, which would of course allow a red response. But that's not when he strikes him. He strikes him when, once again, John Stezel is prone and on the ground. He's weaponless. There's a second officer there. This means he's no longer at this level. He's now at this level, back to active resistance. He's still pulling away. He's still not letting the officers grab hold. He's not just going limp. He's pushing, he's twisting, he's doing what he's doing. But he's not actively assaultive, nor is he dangerously assaultive. So he's down to yellow, which means the only response at that point is a yellow response, or this, which means that an active resistance, yellow, a strike with an impact weapon is not reasonable. It is not permitted. It is an excessive use of force, which means it was a criminal assault. What else does George Johnson say to justify the violence against John Stezel that day? Well, he said, I thought he was going for a weapon, so I took him to the ground. This explains. Why does he say this? Well, to create a scarier and therefore most justifiable reason to take someone to the ground. Because remember, at this point, all he has is that George Johnson is running away from him. But if he's going for a weapon, that justifies a heightened response. However, if you watch the body-worn camera video, John Stezel doesn't reach for anything before being grabbed and forced to the ground. And if you read his own affidavit of probable cause against John Stezel, which you have in evidence in his own use of force report, this is what he says, quote, I caught up with Stezel and grabbed him to stop him and informed him he was being detained. Stezel attempted to pull away and I took him to the ground. In other words, at a time just after the event had happened, when all the details were fresh in his mind, and in their use of force report that is supposed to contain all of the salient information regarding why he used force, he said nothing about him going for a weapon, nothing about reaching into the backpack for a potential weapon. This is a justification he's coming up with later, now that he's in trouble. I cited the wrong section of the jaywalking statute, but he was absolutely jaywalking. So this was his claim today, or sorry, at the hearing for the first time, is that he just put the wrong section of the jaywalking law in his report. He put in section C, which is a failure to use a crosswalk. But as he himself testified, that's only applicable where there's a traffic light. And Johnson himself admitted that's not applicable here. There's no traffic light. What he says is that he meant to put in subsection D, which prohibits a pedestrian from crossing diagonally across an intersection. And okay, people certainly can make mistakes, put the wrong section number. And if you look on a keyboard, a regular keyboard, C and D are really close to each other. So it is certainly possible that a person could make that mistake. But let's look at the context. Let's look at what he's describing this offense to be. Because when you listen to the body-worn camera video, here's what he says. You didn't use the crosswalk. You still have to use the crosswalk. He's not talking about walking diagonally. You read his own affidavit and use of force report. This is what he writes. Male then jaywalk across Bay Street in front of me instead of walking to the nearby crosswalk in violation of 23 Vermont Statute 1052C. In other words, he's talking about failing to use the crosswalk. He's not talking about diagonally. This wasn't a mistake where he put the wrong section letter in, but clearly meant the other thing. He was talking about the crosswalk. Why is this important? Because he's claiming authority to detain based on something he himself admitted he did not have. What other justifications does he make? Well, he said he actually did attempt de-escalation, that his verbal commands to John Stezel after taking him to the ground were, in fact, de-escalation. No. The model policy defines de-escalation as follows, and the highlighted portion is the portion I'll read. The common de-escalation techniques include deliberately slowing the progression of law enforcement actions, using barriers, cover, and distance, as well as communicating in a calm, clear manner, using active listening skills, and asking open-ended questions. George Johnson is claiming that because he didn't shout his commands, that's somehow de-escalation. Well, we discussed this with Lieutenant Ackerland. Who concluded no, and also reminded us that at the same time that George Johnson is giving these commands in a calm manner and not a calm manner, he's also physically grappling with John Stezzle. Far from de-escalating, his commands are further escalating the situation beyond where it is. Well, John Stezzle committed other crimes: disorderly conduct, impeding, simple assault on a protected individual. But read George Johnson's own probable cause affidavit. Each crime isn't a crime before he begins his pursuit or begins his takedown. Each crime comes as a response to Johnson's own actions, which begs the question, was John Stezzle committing crimes, or was he simply acting in defense of himself from a person who had taken him to the ground, was giving him orders, not explaining why, not attempting to de-escalate, and was attacking him? And then we come to the biggest red herring, Brazilian Jiu-Jitsu. Johnson claimed that he knew that John Stezzle was trained in Brazilian Jiu-Jitsu, some form of mixed martial art. And his basis of knowledge was he had taken ground fighting training at the Vermont Police Academy, that he had some exposure to Brazilian Jiu-Jitsu during his time in the military, although he was honest in saying that it wasn't what he was trained on. It was starting to trickle in as he was starting to muster out. And then finally, 1 year at Kaze Dojo in Littleton, New Hampshire. But again, look at his PC affidavit, his use of force report. You'll say that in neither of these does he mention Brazilian Jiu-Jitsu. These were written the same night when all the facts were fresh in his mind. And the use of force report, again, is supposed to thoroughly document all facts that justify his uses of force. He knows this. He's a use of force trainer. And his testimony was that he recognized the techniques of this guy right off the bat. This was significant to him. Why does he want us to believe that John Stezzle knew Brazilian Jiu-Jitsu? Because looking back at that use of force dashboard, it creates a special circumstance that he claims will justify his more aggressive actions. But this isn't something he puts in his affidavit. It's not something he puts in his use of force report. And if you listen to the body-worn camera footage at the scene, when he's talking with Captain Gray or Chief Beers, he never mentions Brazilian Jiu-Jitsu to either of them at the scene of the offense. He talks about being tased a lot. That's almost the second thing that comes, every other thing that comes out of his mouth, but he never mentions Jiu-Jitsu there. It's not till much later that he comes up with this excuse. But we talked to Lieutenant Ackerland, who I remind you is our use of force expert and someone who has a black belt in Kempo Jiu-Jitsu. And while he admitted he's not an expert in Brazilian Jiu-Jitsu, it's an entirely different martial art, he says that his experience with Brazilian Jiu-Jitsu was sufficient so that he would recognize the specific techniques, the guards, the moves, and attacks from that martial art. And his conclusion was he saw no evidence of any martial arts training. And he did so even after watching that video that George Johnson created, some guy off the internet who apparently does martial arts, that he then smooshed next to his body-worn camera footage to create some kind of false comparison. Even looking at that, he said, I don't see martial arts. But let's give George Johnson the benefit of the doubt. Let's assume for a moment John Stezzle was trained in some form of mixed martial arts. Did it make a difference in the conclusion of Lieutenant Ackerland regarding the reasonable use of force? According to Lieutenant Ackerland, no. Why no change? Because the failures to follow policy do not rely on the skill of either person, but on the police officer's responsibility to follow that policy and do what needs to be done. And he failed. He failed to give reasonable time to submit to detention. He failed to reassess when circumstances change. And he failed to attempt any de-escalation techniques. These are his obligations, regardless of whether he's dealing with someone with no skill or someone with all the skill on the ground. And he didn't do it. If anything, if Stezel was trained in martial arts, this wasn't just a failure to follow policy. It was a failure to follow his own training. As we heard from both Lieutenant Ackerland and begrudgingly admitted by Mr. Johnson himself, he's been trained, don't fight somebody where their strengths are. And yet he continuously, throughout the video, you'll see, goes in and tries to wrestle John Stezel on the ground. If truly John Stezel was someone trained in Brazilian Jiu-Jitsu, as George Johnson claims, this would have been a serious mistake, demonstrating that his belief comes late. His belief is something he came up with later, not anything he had there on the day. In conclusion, George Johnson had a hunch that John Stezel was involved in something, likely drugs, given the fact that he was in an area that's known for high drug use, drug sales, etc. Now, there's nothing wrong with an officer acting on a hunch. It happens all the time. But police officers cannot detain on a feeling or arrest on a hunch. A hunch is not reasonable suspicion, or is it probable cause. But for George Johnson, a hunch was enough to take someone to the ground, threaten them, swear at them, spray them with OC spray, tase them, strike them in the face with an impact weapon, causing serious bodily injury, punch them in the back of the head, with his fist multiple times, enough to seriously hurt someone. George Johnson had a responsibility under our use of force policy to consider 5 factors before ever using any force. He didn't. He had a responsibility to de-escalate the situation when possible. He didn't, despite clear opportunities. George Johnson had a responsibility to reassess when the circumstances changed, when another officer showed up, when the totality of the circumstances were different. He didn't. George Johnson had a responsibility to give John Stezel reasonable time to submit to detention. He didn't do that either. George Johnson willfully failed to follow policy regarding use of force. George Johnson. The facts in this case prove by a preponderance of the evidence that George Johnson committed Category A conduct by assaulting John Stezel with a deadly weapon. The facts in this case prove by a preponderance of the evidence that George Johnson committed Category A conduct by assaulting John Stezel, causing serious bodily injury. The facts in this case prove by a preponderance of the evidence that George Johnson committed Category B conduct by willfully using excessive force in violation of statewide and departmental policy. Given the severity of the injury caused to this Vermont resident over nothing more than a hunch, the only proper remedy is permanent revocation of law enforcement certification. This didn't have to happen, and it should never happen over something as trivial as a jaywalking offense. Thank you.
All right, thank you, Attorney Burkett. Attorney Milligan, are you all set?
I am, thank you. I'm going to share my screen and hopefully it goes as smoothly as Attorney Burkett's. Pardon me for a moment while I stop sharing, put that in present mode. Okay, can everybody see my presentation?
We can hear, yes.
Great. I'm going to turn off my camera so as not to be a distraction while I look at it on my other screen. St. Johnsbury, Vermont. It's a town of about just over 7,000 people in the Northeast Kingdom of Vermont. Not unlike many of the other communities in Vermont, over the last couple decades, it's been gripped with increased crime, largely driven by substance use disorder. And the toll it's taken on that community is one that everybody's lived experience in Vermont is something that we can check in with. And while on patrol on May 10th of 2024, Sergeant Johnson was driving by one of these areas known in the community to be a high crime area. And the first thing he notices is Mr. Stelzel. He writes, you'll note that Mr. Burkett repeatedly emphasizes the importance of this and significance of those interviews in the early weeks and the statements made in writing. He writes almost immediately, appeared to be purposely ducking out of sight behind pillars in the pavilion area. At this point, the gentleman leaves, heading north on Bay Street to avoid me, to what appeared to be to avoid me. That's the pavilion there. You can see how you might see in there, and there are pillars supporting the roof structure. And that's where he leaves to. He heads out onto Bay Street. So what do people have to say about this area? What is the context of the moment that we are now examining? It was known to me at the time that a lot of drug activity takes place at the pavilion. I have made multiple arrests in that area and recovered multiple drugs, fentanyl and other drugs from that area. That's Sergeant George Johnson speaking to Detective Sergeant Baker. When George was saying that it's because there's a lot of suspicious activity over there at the pavilion, he's not wrong. That pavilion is a nonstop problem for us with drugs and alcohol, and there's a lot of traffic in there. That's then Chief Joel Pierce. Homeless people and drugs all the time, and there's people shooting up there all the time. I can probably pull up the camera right now and see someone smoking crack down at the pavilion again because they do it all the time. That's Captain Jason Gray. Judge Kanan, who presided over the court in that community for a considerable amount of time, after reviewing this case, agrees the Trailhead Pavilion in St. Johnsbury, where Mr. Stelzel's altercation between Sergeant Johnson and Mr. Stelzel occurred, is known to police and others as a place where people use, sell, and buy illicit drugs. The Trailhead Pavilion is properly referred to as a high crime area. Let's talk about jaywalking for a minute. It's certainly something that the state, beginning with Detective Sergeant Baker's investigation, I respectfully disagree with my colleague, Mr. Burkett, about the thoroughness of that work and the conclusions drawn. He pointed you to the many things she did. One thing she didn't do, for example, was interview Mr. Stelzel, the man you see on your screen right now. But there's been some dispute as to whether there was even jaywalking. Well, I ask you to use your own eyes, and I ask you to consider the opinion of Judge Kanan. There is a jaywalking statute, Section D. It has been 7 years since Sergeant Johnson wrote his last jaywalking ticket. However, Sergeant Johnson did observe Mr. Stelzel jaywalking. Now, a moment ago, I was talking about my exceptions I take with Detective Sergeant Baker's affidavit that you have in evidence in Exhibit 10. She told that judge that one of the first orders that happened in her probable cause affidavit was, don't fucking move. That's the person that concluded probable cause existed after her thorough investigation. This is what actually happened.
Excuse me, what's your name?
Mr. Stelzel responded to those questions asked by Sergeant Johnson with a false name. Now, admittedly, Sergeant Johnson doesn't know this, but you can tell by his follow-up questions that his instinct is he needs more information to believe these statements. Mr. Stelzel responds with the name of Taylor. Taylor Hay is what he claimed. When asked to spell it, he says, why? What's going on? And Sergeant Johnson does exactly what the training says, which means as early as possible, explain the purpose of your stop. You didn't use the crosswalk there and the way you tried to avoid me there, I think. Now, here's an interesting point. The entire second half of that statement was excised from the quote that Detective Sergeant Baker authored to pursue a charge against him. Now, that may seem unique. She's scrubbing it and making it just the jaywalking. But again, you saw Lieutenant Ackerland and you've heard Mr. Burkett continue to repeat this misstatement of fact about the bases for the initial interaction. Mr. Stelzel then interrupts that statement and explanation of why he's interacting with him to say, I didn't use the crosswalk. I'm not in a car, I'm walking. Now, we all heard Lieutenant Ackerland even confirm that was a strange response, which reasonably increases suspicion. Here's the video.
Excuse me, what's your name? What's your Taylor what?
Hey,
Taylor what?
Taylor Hay.
How do you spell that?
Why? What's going on?
Oh, you didn't use the crosswalk there, and the way you tried to avoid me, I
didn't
think.
use the crosswalk?
Yeah,
I'm not in a car. I'm walking.
No,
Again, half of that was excluded from Detective Sergeant Baker's affidavit for whatever purpose she chose not to testify there was a comment by Mr. Perquette that the judge didn't have a use of force expert or anything like that when they made a probable assessment. She was in the room. She chose not to testify. But with respect to reasonable suspicion and the factors that are actually present, Judge Kanan, after reviewing the video, made it clear that Sergeant Johnson acted in a reasonable, lawful manner as he approached Mr. Stelzel. Sergeant Johnson had the authority to detain Mr. Stelzel, to write him a jaywalking ticket, or to satisfy himself that Mr. Stelzel understood his obligation to use the crosswalk. However, to say that Sergeant Johnson approached Mr. Stelzel exclusively to enforce the jaywalking statute would ignore Sergeant Johnson's other observations, which may have, appropriately, increased Sergeant Johnson's reasonable suspicion that a crime was being committed. So, what did he have for factors that would have contributed to that reasonable suspicion? Number one, high crime area with frequent drug activity. Number two, Stelzel ducks behind pillars upon seeing the marked cruiser. Number three, as the officer approaches, Stelzel leaves the area. You even heard Detective Ackerland acknowledge that in his career, that has been enough. And when Sergeant Johnson follows Stelzel north, he changes directions. When Mr. Stelzel, after he changes directions, he jaywalks in front of the cruiser. Mr. Stelzel then refuses to spell his name, which we now know is fake, when asked, and instead asks why he's being stopped. And Mr. Stelzel interrupts Sergeant Johnson's explanation to say, among other things, the jaywalking and the way you tried to avoid me back there. Mr. Stelzel's response was illogical. I didn't use the crosswalk. I'm not in a car. I'm walking. Upon consideration of these facts, Judge Michael Kanan said, Sergeant Johnson had reasonable, articulable suspicion to briefly detain Mr. Stelzel for both jaywalking and to ask further questions. In fact, the law is clear, and these are areas of law that were before the judge. A police officer may stop an individual where there is a reasonable, articulable grounds to suspect that an individual is engaged in criminal activity. And as the Vermont Supreme Court confirmed in State v. Ford, under both the Vermont and federal constitutions, we have recognized that a brief detention, its scope reasonably related to the stop and inquiry, is permitted in order to investigate the circumstances that provoke suspicion. Here, those circumstances are not merely the $59 civil violation, but instead also the drug crime in the high drug area in the community plagued by drugs. But that's not all we had before any use of force is taken upon, right? Because we also have the headlong flight, which, as Chief Justice Rehnquist said, headlong flight, whenever it occurs, is the consummate act of evasion. It is not necessarily indicative of wrongdoing, but it's certainly suggestive of such. In reviewing the propriety of an officer's conduct, courts do not have available empirical studies dealing with inferences drawn from suspicious behavior, and we cannot reasonably demand scientific certainty from judges or law enforcement officers where none exist. Thus, the determination of reasonable suspicion must be based on common sense judgments and inferences about human behavior. So what human behavior did we observe? Well, as Sergeant Johnson exits the cruiser, and I'm going to use terms like calmly, but I ask you to make that own evaluation as I show you these videos. I want you to stop here. Mr. Stelzel responds to that lawful order by running off the sidewalk and into the roadway. What are you doing? Mr. Stelzel yells at Sergeant Johnson as he crosses the street to get to him. You are being detained. Stop. That's a lawful order. Judge Kanan says it. Your own experience and intuition should say it. There is no purpose, whether it's the jaywalking or the suspicion of drug activity, that has been satisfied. And it was a lawful purpose for him to pursue as a law enforcement officer.
What's going on?
Oh, you didn't use the crosswalk there, and the way you tried to avoid me, I
didn't
think.
use the crosswalk?
Yeah,
I'm not in the car, I'm walking.
No, you gotta still use the crosswalk even if you're walking. Yeah, at the end of it. No, I want you to stop here. No, you're being detained. Stop.
What?
As Sergeant Johnson applies an open-handed control technique to seize Mr. Stelzel's backpack, you see Mr. Stelzel immediately begin to actively resist. This is something even Lieutenant Ackerland acknowledged. And in response, Sergeant Johnson warns of his need to use force. You're going to get tased. You better not run. Stop. Sergeant Johnson's voice is raised, but he maintains his composure and makes clear commands. As Mr. Stelzel works to escape Sergeant Johnson's grasp, you hear Sergeant Johnson admittedly say, "Don't fucking move." And Mr. Stelzel further escalates the encounter by raising his knees and hands, deflecting Sergeant Johnson's open-handed control techniques. "Why are you doing this?" Mr. Stelzel asked. "You are going to get tased. I told you to stop." That's the answer that Mr. Paquette laments and claims was never uttered. The reason he's being detained at this point is because he was asked to stop and he fled. That, combined with the other factors, was reasonable.
You're gonna get tased. You better not. Stop. Don't fucking move. Why are you doing this? You're gonna get tased.
Why are you doing this?
I told you stop.
What?
You hear a warning, "You're going to get tased. I told you to stop." In response, Mr. Stelzel continues to resist, and Sergeant Johnson continues to tell him that he is going to use force. Sergeant Johnson at this time is alone, and he's using one hand to try to restrain Mr. Stelzel while radioing for backup. It's around now that you hear the highly distracting but factually inaccurate screams for help. What I mean when I say factually inaccurate is you'll notice later in the video when he needs to be on his feet, he's on his feet in a second. And when other officers respond to the scene, he doesn't turn to them for help. He begins to try to disarm them. So the claim that he is actually seeking help in this moment is disproven by his own conduct.
You're gonna get tased. You better not. Stop. Don't fucking move. Why are you doing this? You're gonna get tased.
Why are you doing this?
I told you stop.
What? Why are you doing this? I'm not doing anything.
Why are you running?
Come, help! Help!
You're gonna get
Help!
tased.
Help! Help! Help!
Stop.
Help! Help!
Fighting with one.
Help!
On base.
Help!
I'm fighting on one.
Help!
I'm gonna-
Help!
You're gonna-
Help! I don't have anything, dude. I don't have anything. I swear to
Stop.
God, dude.
Stop.
I don't have anything. Stop!
You're being detained.
Stop, dude. Why are you doing this? I'm not doing
Why are you
anything.
running?
Come!
I am no master of PowerPoint. But what does the statute instruct us about the use of force? Well, interestingly, Lieutenant Ackerland started with the totality of the circumstances from 20 VSA 2368, and I was able to confront him with the rest of the statute, which in part says a law enforcement officer shall not be deemed the aggressor or lose the right of self-defense by use of proportional force if necessary to effect the arrest or to prevent escape or to overcome resistance. So was this a high danger situation? Well, the academy teaches that injury or exhaustion, close proximity to firearms, special knowledge, and being grounded are all relevant factors. You heard Sergeant Johnson testify that he has repeatedly used the shrimping technique in his own training in jiu-jitsu and in ground combat. He is a VCJC certified ground combat instructor as well. He has spent his 14 years as a law enforcement officer continuing to develop his training in this regard, and he tells you that he perceived that. Now, much is said about the lack of its inclusion in the initial report, but you have the video, not just the video that is complained that it's just a guy on the internet, but you have the actual video of John Stelzel. And what you see is Sergeant Johnson, despite his training, and Officer Johnson later, never being able to do as much as seize his hand. An officer with 14 years experience is unable to seize his hand, and every time he brings his body closer to Mr. Stelzel, it results in serious injury. And yet it is meant for you to disbelieve that in that moment, Sergeant Johnson concluded this man was a trained fighter. As Sergeant Johnson continues to call for backup and to yell, he wriggles out of his backpack in a way that Sergeant Johnson will continue to have, is continuing to try to gain control. He continues to yell, "I'm not doing anything." And Sergeant Johnson continues to repeat his commands to stop.
Dude, stop. Stop. Sean, stop. I'm not doing anything,
Stop.
dude. Please stop.
I'm in
Help!
Bay Street.
Help. Stop, dude. Come on.
Grab me, I'm gonna
I'm
punch
not doing nothing.
Stop.
Help. Help. Help, dude. Come on. Stop. Help. This cop's doing something. Help me. Help. Help. Stop. Stop raping me. Stop.
You hear Mr. Stelzel, and look, it's disturbing. Nobody wants to see a law enforcement officer on his feet and a citizen on the ground screaming that someone's raping me. But the truth isn't changed by the audio here. The reality that we see with our eyes is that an officer is struggling to gain control over a suspect he has yet to complete his initial inquiry with. Next to that man has just fallen out of his pocket a knife and a crack pipe. And yet we're still meant to believe that this is a jaywalking stop. Roll over on your back now, Sergeant Johnson states. Oh, I think I missed a video there, no? No, I didn't. Roll over on your back, Sergeant Johnson states. Put your hands behind your back. You are under arrest. Or what? I'm not doing nothing. You are under arrest. Mr. Stelzel continues to scream. It's going to get worse for you. That's the warning. All these claims by Mr. Burkett that he never waited, that he never gave him time to comply. This is that time. This is him saying roll over. This is him saying you're under arrest. There is persistent resistance and escalation. Last chance to roll over on your own. Pretty clear levels of progressive warning of what's to come. I'm going to have to spray you. He continues to scream and ignore the commands.
Stop! Help! Help! Stop! Stop! I don't have anything. Stop! For what? I'm not doing nothing.
You're under arrest.
Help!
You're under arrest.
Stop!
It's gonna get forced.
Stop!
I'm gonna use force.
Stop!
Last chance to roll over of your own.
Stop! I don't have anything. I don't have. Stop, dude! Please.
Now, again, you hear a lot of strain and stress in Mr. Stelzel's voice, but what you see actually happening is that Sergeant Johnson is merely trying to keep him still and give him commands. You can barely hear Sergeant Johnson's voice. But after warning that this was your last chance to roll over on your own and that I'm going to have to spray you, you see Sergeant Johnson deploy his OC spray. Once he makes that single spray to Mr. Stelzel's face, you can detect no discernible change in Mr. Stelzel's resistance. It's apparent on the video, and it's clear that in the moment, Officer or Sergeant Johnson felt the same way. Not sure why there's no audio there.
Stop! Stop! Help! Stop! Stop it!
So what was the result of this first deployment of this particular force of the OC spray? Sergeant Johnson describes how Mr. Stelzel wiped it from his eye, reached up and gouged him in the eye. Is there any proof that that happened aside from this 14-year veteran's word? Yes. You can clearly see the swollen left eye of Sergeant Johnson taken that night, and this photo was nearly instantly provided to the investigators in the case. As he described it in that crucial early report, Mr. Stelzel grabbed my left thumb and twisted it, causing pain. I pepper sprayed Mr. Stelzel and he wiped it off of his face and with the same hand gouged his finger into my left eye, causing me pain and loss of vision in that eye. Now, let's talk about what happens in the moments that follow the eye gouge from Mr. Stelzel. First, I asked this of Lieutenant Ackerland, who drew the taser? And he says, well, I read that someone else did it, but I wasn't necessarily able to see it. It was hard for me to tell. A slowed version of the video clearly shows Mr. Stelzel trying to grab his OC canister from Sergeant Johnson's right hand, and then he reaches up to Sergeant Johnson's chest and pulls his hand back. He's firmly grasping the taser with one trigger. Sergeant Johnson's right hand, which he would have used to draw the taser, clearly comes from the right of the screen, and he is still holding his OC before it is knocked from his hand. There's no room for argument. Mr. Stelzel is the one that drew Sergeant Johnson's taser. This is a very slowed down version. That's him reaching for the OC spray in Sergeant Johnson's hand. That's him reaching up for Sergeant Johnson, where all of his weapons are to be found. That's the taser in Mr. Stelzel's hand with his hand on the trigger. That's him trying to get underneath the defensive gestures of Sergeant Johnson, but the safety's on. Even Judge Johnson says, Mr. Stelzel then grabbed Sergeant Johnson's taser. Despite Lieutenant Ackerland's inability to draw this conclusion, you can. Let's talk about the taser deployment. Mr. Stelzel snatches the taser from his Sergeant Johnson, and there's a quick deployment by Sergeant Johnson. You don't see any meaningful reaction. Again, now he's tried OC spray, no effect. Taser, no effect. You're going to see that happen repeatedly throughout this interaction. He's being warned throughout this process. Continuously, Sergeant Johnson deploys his training to continue to warn that these things are going to continue to happen. Now, I ask you to assess the relative calmness in the voices, who's trying to de-escalate the situation with the tools available to him, given this split-second escalation, an escalation that undoubtedly happened when Mr. Stelzel disarmed Sergeant Johnson.
Stop! Stop it! Help!
Stop.
Help! Help!
You're gonna get shot.
This is what Mr. Burkett calls misleading. When I say that Stelzel had a weapon, that he was on top of Sergeant Johnson. I'll let you draw your own conclusion about that. According to the judge, Mr. Stelzel reached up, grabbed the taser, and tased Sergeant Johnson. As Sergeant Johnson was tased, Mr. Stelzel stood up and appeared to gain the upper hand in the altercation. Mr. Stelzel quickly got on top of Sergeant Johnson. When Sergeant Johnson looks up at Mr. Stelzel, this is a still image that is from his own body-worn camera. You also have the benefit now, because it's come into frame from the trailhead camera, and you see that Officer McKendrick Johnson has arrived in response to that call. Now, Mr. Burkett points out that Officer Johnson didn't want to wait the full 2 minutes before backup arrived. But anybody that's called for backup knows you don't know when backup is going to arrive. They don't announce their ETA. You do your best to let them know where you are, and you continue about the task of keeping yourself safe until they get there. Now, Mr. Stelzel's attack continued as Officer Johnson arrived. And for the ease of my own narration, let me just, when I can, call him McKendrick Johnson. But that timely backup was helpful. And as he arrives on the scene, he runs to the aid of Sergeant Johnson, and several things happen. I'm going to discuss some of those with you. But one of those is that he instantly observes Sergeant Johnson's firearm as a subject of interest to Mr. Stelzel. The contention that this may be a post hoc police talking to each other to come up with a story is rebutted by this body-worn camera from McKendrick Johnson, which clearly shows that he hadn't talked to Sergeant Johnson about it. And he says, I saw the male reach up for Sergeant Johnson's firearm. That's what he writes in his report. What does he say still at the scene?
Came around that corner and he was trying to grab it looked like he was trying to grab George's gun.
Looked like he was trying to grab George's gun. That's the scene he arrives to. Now let's talk about the use of force dashboard. From the moment Sergeant Johnson exits his cruiser, a fleeing Mr. Stelzel puts us in active resistance. He's pulling away, he's escaping. Lieutenant Ackerland acknowledged this. Mr. Stelzel continues to match the active resistance as he goes to the ground, hand fighting Sergeant Johnson. This active resistance is further defined as struggling, not complying on physical contact, and where injury is less likely. There's no doubt that that's where we were in the beginning of this process. And based on this assessment, Sergeant Johnson accurately assessed that aerosol spray might be the appropriate use of force, but he warns it several times before deploying it. Now, we all saw when he is repeatedly asking him to stop and turn over and warns him that it's coming. We see that he reaches into his vest and eventually deploys it. Now, nothing happens in response, and that is to say, you don't see Mr. Stelzel comply. It's incumbent upon me at some point to point out the notion of excess, right? Excess means more than needed. And how are we to examine something as simple as roll over, and he doesn't? How could the force be excessive? Well, we have to get more granular about how we've defined that term a little better. So what does the use of force dashboard continue to say? Well, now at this point, after the OC spray, Sergeant Johnson's now been gouged in the eye. That's a felony by Mr. Stelzel. And Mr. Burkett pointed to you, hey, this is all real serious for the crosswalk violation. Well, the law is equally clear. This was all before Judge Kanan. Vermont Supreme Court has held that if you disagree with the fact that you're being arrested, your remedy is not to fight or disarm or shoot a taser at the officer conducting the arrest. The remedy is to submit to the arrest and to take your procedures to the court. You have those meaningful protections for a reason, and that's better for everybody. That's clear Vermont law. It's actually something that's adopted in nearly every state. You cannot actively resist a lawful use of force. Now, there is an argument, in fact, that the gouging of the eye, which has serious injury potential, namely the inability for Sergeant Johnson to continue to perceive the person he's interacting with when he's gouged in the eye, that alone has been and could be argued elevated this to deadly aggression. But again, we don't need to be as extreme in our analysis. He accurately assessed that orange would be appropriate, and the defensive tactics applied there: impact weapon strikes, empty-handed and body strikes, conductive energy weapon. So what has happened so far? He's been gouged in the eye, and now it's time to escalate to the next step. The next step is taser, conductive energy weapon. That's what it says right here in the training. So what does Sergeant Johnson do? He does exactly that. He warns that he's going to use his taser, and then he does. Does he actually draw it to escalate it that quickly? No. The rules say go as slowly as you can, and he did not elevate despite those prior warnings. It was Mr. Stelzel that elevated this. Based on everything the academy has trained him on, Mr. Stelzel is now is at the edge of using deadly aggression. And when Sergeant Johnson has been trained to appropriately respond, and we talked about this with Lieutenant Ackerland, deadly force is justified. And what are those options listed in the training materials? Firearms, vehicle, neck restraint. Those are all things that Lieutenant Ackerland himself acknowledged were more lethal. They were more dangerous selections for Mr. Johnson. So what is the only remaining tool available to him but impact weapons? I want to take a minute to talk to you about the de-escalation process. I think de-escalation is important. I know Sergeant Johnson feels that he deployed every de-escalation technique he could viably do. And I also know that Lieutenant Ackerland testified somehow that he deployed none of them. So curious and leaning very heavily into this 200 plus slide deck training of the VCJC, I wondered, what are the methodologies for actual de-escalation? There's a very clear chart about what items or tools he can use when he selects force. What's the process here? This is a video of me trying to find the word de-escalation in the PowerPoint slide. Searching for the term de-escalation, you notice I'm not selecting match case, which means it will find anything close. That's the first mention. They're critical. No disagreement. That's just the word with no definition. Here's a couple longer ones, which I'm going to get into in a moment. And that's it. That's the whole of training that we have in the VCJC training materials to equip an officer to do this crucial task. So what are de-escalation techniques? Well, of all those slides, as I just shared with you, it's only mentioned 4 times, and most of them just mention the word de-escalation without any clear description of what it is. But there are definitions of de-escalation in the use of force statewide policy. Mr. Burkett pointed you to some of that earlier, not all of it, perhaps because this is exactly what Sergeant Johnson did. De-escalation may include the use of such techniques as scene management, calm, respectful, and clear communication. I believe when he was saying it wasn't adequate, Mr. Burkett said that, because he was speaking calmly doesn't count. Well, this is him being told in one of the rare moments of clear instruction on it that it is. Use of warnings. Again, we've repeated that there were multiple warnings. And deliberately slowing the progression. Like, for example, threatening the use of a taser, but not brandishing or drawing it. 2 minutes and 3 seconds. That's the period of time from when Sergeant Johnson first exited his cruiser and for the threshold inquiry until the actual event, to when Mr. Stelzel got on top of him. During that 2 minutes and 3 seconds, Sergeant Johnson gave Mr. Stelzel 27 different verbal commands and warnings. Nearly every one of those 27 were commands and warnings, which are defined as de-escalation techniques. Here's a rundown of them. I want you to stop here. You're being detained, stop. You'll notice these are seconds apart. You're going to get tased. You better not. Stop. Don't fucking move. You're going to get tased. I told you to stop. Why are you running? You're going to get tased. Stop. 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 You're being detained. Stop. Stop moving. Grab me and I'm going to punch you. Stop. Stop. You're going to get hurt. Roll over on your face now. Put your hands behind your back. You're under arrest. Again, these are seconds apart. I'm arresting you now. Now you're under arrest. It's going to get worse for you. I'm going to use force. Last chance to roll over on your own. You're going to get sprayed. Stop. You're going to get shocked. That's de-escalation in 2 minutes of a rapidly escalating situation where nobody knew when he pulled over for that drug investigation, that jaywalking, that this was going to happen. But to contend that these were decisions made by Sergeant Johnson belies what you can hear and see with your own ears and eyes. Now, as Sergeant Johnson is falling to the ground, or Officer Johnson is falling to the ground, we know that McKendrick Johnson arrives. And as McKendrick Johnson arrives, the government, the state is telling you, this is a moment where we should view that now the upper hand has been gained, that there should be a rapid de-escalation, which, by the way, there is a de-escalation eventually, but we'll get to that. This is the moment that it is supposed to be comforting to Sergeant Johnson. Let's see what actually happens as Officer McKendrick Johnson runs to the scene. You notice Stelzel's able to keep his eye on the approaching person. He cocks back the weapon to strike him before falling to the ground. In a moment, you're going to see Stelzel reach up to try to grab Mr. McKendrick's weapon. See him reach there? He falls back down. That's not his last attempt to disarm Sergeant or McKendrick Johnson. He just reached for it again. That's 2 attempts to disarm McKendrick Johnson in the seconds after he successfully disarmed the highly trained use of force instructor, ground combat instructor, Sergeant George Johnson. And we are meant to conclude from this that somehow the safety factors have gone down or have gone up, and the need for use of force has gone down. So, the judge, when he read this, when Officer Johnson arrives, Mr. Stelzel's hand appeared to be raised and cocked back. He reached toward Officer Johnson in what the court believes was in an attempt by Mr. Stelzel to take Officer Johnson's taser. Here's an even further slowed down angle on this. And remember, Mr. Perquette and Lieutenant Ackerland say he's not on top of Sergeant Johnson. He's between his legs and rising above him in these moments. He's cocking back a fist to strike back up. At nearly this precise moment, you hear Officer Johnson himself start to give verbal commands. Stay down. Mr. Stelzel has twice disarmed Sergeant Johnson, and still you have Officer Johnson and Sergeant Johnson repeating commands. Roll over. At this point, Mr. Stelzel's deadly aggression, that is the attempted continued disarmament, not only of Sergeant Johnson, but also of McKendrick Johnson, is plainly visible in the video.
Stay there! Stay there! Stay there! Roll over!
Now, let's talk about the impact weapon strike. As we saw when we looked at the dashboard, it's plain that deadly aggression occurs when someone is disarmed. It's plain that deadly aggression occurs when there is serious risk of serious bodily injury to the officer or to others. What is also plain to everybody that's watched these videos carefully is that Sergeant Johnson has tried every technique. Every verbal command he can give, he gave. Every warning he can give, he gave. He called for backup. That's something he's supposed to do. And then what happens next? He deploys his OC spray. What happens in response to OC spray? No effect on Stelzel. Blinding attempt at blinding eye gouge on Johnson. So he warns the next step, conductive energy weapon. But does he actually escalate? No, Stelzel actually escalates. So we know that that's not a viable tool for him. In fact, Lieutenant Ackerland tells you that after he is shot with his own taser, Sergeant Johnson should be aware that that is now out of ammunition in terms of distance deployment, and drive stun are the only options. Now, you'll read in Detective Sergeant Baker's report, and you might have heard Mr. Perquette earlier suggest that's somehow inappropriate, but it's the only method available in remaining with the tool that he had available to him, the least lethal method. Now, as you see the impact weapon strike.
Stay there! Roll over!
Oh!
Hit him with it.
Stop!
Hit him with it. He already tased
Stop
me.
it!
Mr. Perquette wants you to conclude from that video that that's angry George Johnson telling somebody to retaliate by striking this person. But remember that you've already watched McKendrick Johnson make his own repeated verbal warnings, but you didn't see him, or you know he wasn't there during the OC deployment or Sergeant Johnson's deployment. Sergeant Johnson is instantly informing him of the predicates he would need as Officer Johnson's own assessment of the necessary use of force is determined to make that decision and deploy it. A single impact weapon strike to get him to stop fighting. Now, what you're going to hear, or what you heard Mr. Paquette repeatedly say, was that this was unnecessary because there's a second person on the scene. Well, unless you count the fact that that second person on the scene is less trained in both combat and experienced as a police officer, unless you count the fact that in his first seconds on arrival, you saw Mr. Stelzel repeatedly try to disarm the new arrival.
Roll over!
Continue.
Oh!
Hit him with it.
Stop!
Hit him with it. He already tasted
Stop
me.
it! Ah!
You know, even with the strike, which admittedly caused damage and is regrettable, and there's no disputing that nobody should be injured like this where it's avoidable. The question is whether this was avoidable and whether it was the consequence of Mr. Stelzel's resistance or whether it was the consequence of Mr. or Officer or Sergeant Johnson. Now, you heard Lieutenant Ackerland acknowledge that an impact weapon is the appropriate use of force where deadly aggression is present, and he's continuing to yell, roll over. Sergeant Johnson continues, even as he strikes him, to tell him, you need to roll over. None of these commands are things that you hear or see Mr. Stelzel acknowledge. The final use of force, there's a single strike and he abandons his weapon. And let me just take a moment to disagree with my trusty colleague, Mr. Paquette, about, he tells you that Sergeant Johnson placed his firearm on the ground and then Mr. Stelzel over the top of it. Is anybody with real world experience in a scuffle pretending that these are deliberate gestures, that these gestures are architected at such a level that this is what's animating these moments? No, the reality is his weapon was next to a man's hand, and that man had recently shot him with that weapon. Both officers are using their training and strength to try to turn him over, and even with the injury, it is a challenge. Sergeant Johnson told Mr. Stelzel, stop resisting, put your hands behind your back, and there is yet still no compliance. He has used every tool on his belt. He's been twice injured, and he deploys a less lethal use of force. That is a punch to the back of the head. Less than the taser, less than the impact weapon. He deploys a reduction in force in that second following his use of the impact weapon. The drive stun, that last piece, the drive stun, let's talk about it. Of all the things that were deployed to try to get compliance, none of them were even acknowledged by Mr. Stelzel until you get to the drive stun. So does it actually result in compliance, or do you still yet again see an act of resistance that could equally be interpreted as yet another attempt to disarm Sergeant Johnson?
Stop it, dude. Stop.
Turn over. You get tased again.
Ah!
You get the impact. Don't grab.
That was him grabbing for the weapon after he grabbed Sergeant Johnson or Officer McKendrick Johnson's leg. Now that his hand is where it needed to be to safely cuff him, you will see no further use of force. This case was never about jaywalking. It was always about a police officer who had more than sufficient probable cause at a minimum to make an investigative contact. And the case is truly about what happened after that first lawful, reasonable, polite, investigative contact that Sergeant Johnson made with Mr. Stelzel. It was merely an excuse me. However, the state, beginning with Detective Sergeant Baker's investigation, continues to try to convince you that this is all about jaywalking. In fact, it is a cornerstone of Lieutenant Ackerland's analysis that these actions exceeded the necessary use of force, that this was merely a jaywalking interaction. Your position, I asked him, is that this was offensive for Sergeant Johnson to pursue when he fled, because that would have been the time to stop it all. And Lieutenant Ackerland's response, for a traffic ticket, that's correct, and shortly after. But your testimony is flight should have prompted Sergeant Johnson to stop his potential engagement and use of force. For a simple traffic ticket for jaywalking, yes. On further examination, what did we hear? Right. And your position is it was offensive for Sergeant Johnson to pursue him when he fled, because that would have been a time to stop it all.
For a traffic ticket, that's
Yeah.
correct.
Well, we'll talk about the traffic thing in just a minute, but you agree that retreat is specifically listed, and to prevent escape is specifically listed as something he doesn't need to desist. In other words, well, I'll just read the statute again. A law enforcement officer who makes or attempts to make an arrest need not retreat or desist from his or her efforts by reason of resistance or threatened resistance, right?
It says.
But your testimony is the flight should have prompted him to stop his potential engagement and use of force.
Or a simple traffic ticket for jaywalking.
So let's talk a little bit about that. This is how that conversation continued. So Sergeant Johnson initiates a threshold inquiry based on the two factors we talked about. You agree, right, that there were two factors, not one? Okay. I'm not. You don't need to. Okay, if you disagree, say it.
No, yes, I did.
Yeah, there were two factors, and one of them was the possible investigation of a drug crime in a high drug area. Right? Lieutenant Ackerland also made a point to suggest that the best move was to keep that distance. Just a few thoughts about that. First, for whatever reason, Lieutenant Ackerland's analysis discards the presence of Dylan Chase as a member of the public. It seems to disregard the fact that Officer McKendrick Johnson, who arrived, was himself the subject of an intended attack. You can see Mr. Stelzel cock his arm back. You can see Mr. Stelzel reach twice for McKendrick Johnson's taser. And even when confronted with his own record of activity, where mere suspicion was all he had, he acknowledges that some officers closed that gap. Are you familiar with the name Eric Weinman?
So.
Is he a person that you arrested in 2014 after a bank robbery?
Yes.
Yeah. You were walking and you saw him walking fast away from a crime, away from a bank, right? And that inspired your suspicion, didn't it? So you followed him, right? And then you actually encountered him inside of a different facility, VBA or VNA, right?
Visiting Nurse Association.
Yeah, you remember now, right? I knew your memory was going to work, right? And when you first approached him, you didn't know his name, right? You didn't see him commit a crime, correct? But you, based on the suspicion you felt in that moment, pursued him.
I followed him. He was unaware of my presence until he was in the parking lot of the Visiting Nurses Association. He looked up and saw me in my car, and then he entered the building.
Yeah, so he actually responded to seeing you by flight, right?
Walked into the building.
You didn't stay outside that building and call for backup, did you?
I did not.
You went in, right? You
Yes.
closed the gap, didn't you? So, was Sergeant Johnson obligated to let Mr. Stelzel go in the moments he pursued him? Well, we know what the statute says. It says that an officer cannot be deemed the aggressor for failure to desist or retreat. What did the judge have to say about this? Judge Michael Kanan? Sergeant Johnson had the authority to detain Mr. Stelzel, to write him a jaywalking ticket, or satisfy himself that Mr. Stelzel understood his obligation to use the crosswalk. However, to say Sergeant Johnson approached Mr. Stelzel exclusively to enforce the jaywalking statute would ignore his other observations, which may have appropriately increased Sergeant Johnson's reasonable suspicion that a crime was being committed. The emphasis on exclusively was in Judge Kanan's original decision. I think that's Exhibit 10 for you. And the use of force policy lists several factors in considering the reasonableness of use of force. I note that you were shown a similar list from a different part of the same policy that misses the language that's found both in the definitions section as well as in section 3G, where it's not just the seriousness of the crime, it's also the suspected offense that is a relevant factor. So again, underscoring the significance of not merely the jaywalking incident, but more potently, the suspected offense of drug activity in a high drug area of a community wrecked by drug problems. The level of threat or resistance presented by the subject. It went from yellow to deadly aggression in a matter of seconds. From active resistance to deadly aggression in a matter of seconds. Whether the subject posed an immediate threat to officers' safety and danger to the community, again, disarming, shooting, eye gouging are all active felony crimes committed against Sergeant Johnson, all of which are clear evidence that there's an immediate threat to officers or a danger to the community. Now, there's evidence that Dylan Chase was nearby and that as another officer arrived, that he was instantly subjected to Mr. Stelzel's quite capable attacks as well. All that is to say, when the statewide use of force policy lists the factors to be considered, in the seconds he had to make these decisions, Officer Johnson followed each one of these and found quite an extreme response. So what does the statewide use of force policy stress us to consider? First, the totality of the circumstances, meaning the conduct and the decisions leading up to the use of force and all facts known at the time, including the conduct of the persons involved. Now, that's pretty starkly contrasted to the repeated efforts of the state to suggest that, no, you really have to start the clock again at 0 after the impact strike, or you have to start the clock again at 0 as McKendrick Johnson is running. No, it is appropriate in the moment for an officer to attempt to dial back his use of force. As Lieutenant Ackerland acknowledged, you could dial all the way back to orange in those moments and still use an impact device as you were trained to do. Whether a decision by a law enforcement officer to use force was objectively reasonable shall be evaluated from a reasonable officer in the same situation based on totality of the circumstances. The calculus of reasonableness must allow for the fact that police officers are often forced to make split-seconds decisions in the moment about the amount of force that is necessary in a particular situation, in circumstances that are tense, uncertain, and dynamic, and rapidly evolving. Anybody that watches that video could use any one of those terms to fairly describe what was happening. It's also the policy is also careful to avoid encouraging the additional risk of harm. Officers are not required to use or consider alternatives that increase danger to themselves or to others. Nothing in this policy requires an officer to assume unreasonable risk. In assessing the appropriate use of force, the safety of the public and the officers is paramount. So again, what do we have going on in these moments? We have a trained officer who knows that he lacks the fighting skills, the ground fighting skills, to even get up to this guy's torso. That each time he's attempted to use first an OC spray and then a conducted energy weapon, it has been ineffective in even changing the man's demeanor. And in fact, has both times resulted in him being assaulted and him suffering injury. So the tools available to him, as as we understand, he's out of shots from a distance on his taser. He's used his OC spray, and that's fallen to the wayside. So now he has available to him an impact device, which he uses a single time, and then he deploys closed fist strikes. Now, let's be clear. What are the things Lieutenant Ackerlin laments he didn't do? He keeps saying he should have taken a step back and reassessed what tools he could have used. But what you didn't hear was what those are. What are the tools on that dashboard that we haven't discussed? All of the other options are more lethal. As Judge Kanan concluded, upon a careful review of the charged incident, the court determines that Sergeant Johnson's use of force was within the scope of privileged use of force by law enforcement and was fundamentally reasonable under both Vermont law and the Fourth Amendment. Now, you heard a different quote from Mr. Burkett. He pulled from a different section where the judge was responding to our arguments about how the probable cause complaint was conducted. What he left out, and what you should read in Exhibit 10 if you need to, is that the judge then undertook his own analysis of the evidence before him, including a careful review of the video and the use of force policy. And he explicates in detail each step that he found as a factual predicate for this to happen. So go here. Stop the share. Have I stopped sharing?
Yes, you have.
Yes.
Okay, great. Now I turn my camera on. "11 years in the military, 14 years patrolling and protecting the community of St. Johnsbury, an unblemished record with no prior visits to the VCJC for anything but training. You've got a man who literally did everything he could do to build up the skills he needed for this rare but dangerous moment that might have presented itself. And in that rare but dangerous moment, he meticulously applied the training that he'd received. He escalated at each interval after warning, after clear statements of intent, and after an opportunity to comply. I'm not sure how many seconds in a ground combat that Lieutenant Ackerlin or Mr. Burkett would have allowed a person like Mr. Stelzel, but I respectfully submit to you that you could, in fact, conclude that these were reasonable deployments of force. The other thing I think is just astounding about this process is you've got a guy who served for 14 years with an unblemished record, who undoubtedly was in a high drug area and undoubtedly was pursuing drug-related potential investigation. And there's so much skepticism about what he says happened that day. From where does this skepticism arrive? How do we so reflexively distrust Sergeant Johnson's claims about what he perceived that day, when we can tell how seriously and conscientiously he took his obligation to be trained for that moment? What I think the VCJC should do is conclude that the state has failed to meet any form of its burden in suggesting that this was a felony, much like the judge did. And I suggest to you that you should equally conclude that this was not excessive force in a way that constitutes a Category B violation. If your lived experience tells you, and I just want to acknowledge that the people that are going to be making this decision have important lived experiences. Many of you are law enforcement. Others of you spend more time with those citizens in our life that really need the protection and the acknowledgement that somebody is making sure that those trusted with power are using it judiciously. Sergeant Johnson doesn't dispute that. I don't dispute that. This is an important process. But the prospect that he would be decertified as a law enforcement officer as a consequence of this grave event that undoubtedly happened progressively as it was escalated by Mr. Stelzel is, to me, an opportunity for this board to recognize its own role in this process. He took every training that was available. There's very little training about de-escalation, but I submit to you that what was written was acted on by Sergeant Johnson. And the last thing I'll say about this is as follows. It is a tragedy that Mr. Stelzel's life included this moment. And by what we can see in the video and what we can infer, probably there's been a few tragedies in Mr. Stelz's life. And I know that Sergeant Johnson didn't intend to contribute to that list. How do I know that? Because the moment he gets the handcuffs on him, the next thing is medical treatment. The next thing is respectful dialogue. The next thing after that is bringing him to court. And you never see any indication of animus. It is important that law enforcement acknowledge the limits of what their power, but it is equally important to acknowledge the limits of human perception and the deployment of training in those crucial moments. There is no credible argument that Sergeant Johnson is responsible for the escalations that happened on May 10th. And there is further no credible argument that he committed a felony or a Category B violation. And for that reason, I ask you to send him right back where he belongs, to the community of St. Johnsbury, protecting those good people. Thank you.
Thank you, Mr. Milligan. Attorney Burkett, did you have anything you wanted to add?
Yes, hopefully a short rebuttal, although realize that's a lawyer saying that. But I have to take issue with one of the last things that Mr. Milligan said, because it completely sticks in my craw. The next thing was medical treatment. The next thing was respectful dialogue. If you watch the body-worn footage, neither of those things is true. That's not what George Johnson did. He was asked to just stop leaning on the guy. He's in handcuffs, he's in leg irons, and that's what he asked. And his response was, "Fuck you. You already tased me." You can hear the anger in his voice, and you can hear the anger as he's storming around even afterwards, complaining about being tased, complaining about the fact that he still thought there was a taser prong in his body. Medical treatment is the next thing? No. That didn't happen until Captain Gray turned to McKendrick and said, "Have you called for medical transport?" Oops. I'm adding the oops. But it took the captain, who was off duty, who came to the scene as a response to the initial call and was there again within a few minutes before anybody thought to get medical treatment for John Stezel. This wasn't respectful dialogue. This wasn't medical treatment. This was a rare and dangerous moment, but it was a rare and dangerous moment that was created by George Johnson. This was a rapidly evolving incident, which is why having a use of force expert is so valuable. Because as Mr. Milligan says, and I would acknowledge, certain things that are perfectly acceptable might look bad to a layperson. As you watch it, as you listen to it, as you see it, you might see something that to a layperson's mind looks unreasonable. Having a use of force expert who is trained in the policy, who trains others in use of force, who trains trainers in use of force, is valuable for those things. As I stand here, I'm not an expert use of force. Mr. Milligan is not an expert use of force. Despite his writing it, Judge Kanan is not an expert in use of force, and he did not have the advantages of a use of force expert. And even George Johnson, even though he is a trainer, is not a use of force expert. That is why listening to Lieutenant Ackerland is necessary. And you would think that somebody who is trained in use of force and ground fighting as an instructor would be able to find alternative techniques than clubbing somebody in the head, a red zone that he knows is a red zone, that he's trained as a red zone, that there are better ways. In McKendrick Johnson's video, you can see at this point that at the point that he strikes him, he has control of the man's hand. He's holding the man's hand. And are we saying then that he could not have used any alternative but striking him in the face and breaking his bones, that there was nothing else he could do? I would suggest to you that's not true. Mr. Milligan brought up Lieutenant Ackerland's own association with a man named Weinman. I'm glad he did. Because the point of Weinman was that, yes, officers can have hunches, officers actually can act on those hunches. That's what Lieutenant Ackerland testified that he did. He saw a guy who was looking suspicious around a bank. He followed him. He followed him into a parking lot. When the man saw him, he immediately went to the Vermont Nurses Association, and yes, Lieutenant Ackerland followed him in. But what you didn't hear is you didn't hear that Lieutenant Ackerland took this man, Mr. Weinman, a bank robber, to the ground, or that he assaulted him, or that he put him in a headlock, or that he had to deploy OC spray, or that he tased him, because none of those things happened. Lieutenant Ackerland created a field contact, which, as he said, George Johnson began as. And as he said, in his own professional expert opinion, that was perfectly acceptable. We want that. But he escalated it beyond that in thinking that his hunch somehow created the right to detain. Mr. Milligan quotes the Supreme Court. Let me do the same. The Vermont Supreme Court in State of Vermont versus Emelo said that the rule is that while the act of flight may be indicative of guilty knowledge, it does not provide a proper basis for an arrest. This is because the mere act of fleeing, or some other furtive gesture is an ambiguous act. Therefore, the act of running away cannot alone provide any officer with probable cause to arrest or detain. To hold otherwise would mean that a vague suspicion could be transformed into probable cause for an arrest by reason of ambiguous conduct, which the arresting officer themselves has provoked. That's the Vermont Supreme Court quoting the U.S. Supreme Court. So in other words, the fact that John Stezzle chose to run might, again, look bad for him, but isn't by itself, without more, enough to detain. Something that Mr. Kanan, in his decision, apparently ignored. We heard that McKendrick Johnson observed things that George Johnson did not, and he claimed that he saw Stezzle reach for the gun. Well, Detective Sergeant Angela Baker tried to interview McKendrick to get his perspective, to determine if what he said was accurate, to determine whether or not it was true. As you'll see in the investigative narrative, he lawyered up. He refused to talk. That's suspicious. And it leads us to have suspicion about anything that McKendrick could have said on the scene, anything that he might have said afterwards to other officers, anything at all. The idea then that we can rely on McKendrick Johnson to be an accurate truth teller beyond what his body cam footage shows, which has no agenda, no biases, we cannot. Mr. Milligan showed you the photograph that he claims shows a swollen left eye. You will have to make your own determination as to whether that eye, an eyelid, I should say, is swollen or not. To me, it doesn't appear swollen, but I am not the ultimate finders of fact. This council is. But one thing that is significant about that is the sclera, the whiteness of that eye. It's pure white. Remember, his claim is that the man reached up, gouged his eye, and wiped OC spray into it, bad enough that he couldn't see out of that eye until hours later. That kind of contact would have reddened the sclera. It would turn that white into bloodshot red, even hours later. And he acknowledged that that is the way it happens. That's when you're sprayed with OC, that's what you get. And anybody who's been sprayed with OC knows that. Look again at that photo and see that his bone white sclera in his eyes belies the idea that anything happened. Something that, again, you don't see on the body-worn camera footage. We have only his word. And his word, in this circumstance, isn't good. Mr. Milligan says it's surprising that we are so skeptical. Well, but we're not. Lieutenant Ackerland began his review not with the videos, not with the affidavit of Detective Sergeant Baker, but with George Johnson's own reports. He started from the perspective of George Johnson. And all the way through, we have provided him with the benefit of the doubt. We asked the question, what if he had grabbed it? What if he had grabbed at him before striking him, clubbing him with the taser? Would that change whether or not this was a reasonable use of force? The answer was no. We asked, well, what if Mr. Stezzle had martial arts training in Brazilian Jiu-Jitsu as claimed by this respondent? We gave him the benefit of the doubt. But the person who has the greatest skills, experience, and knowledge in use of force said that doesn't make a difference. This was still excessive force. Mr. Milligan described this as regrettable. It is. And it's regrettable that it may end a career of 14 years. But an offense, even if it's the first time, has to be treated with a serious level of seriousness necessary. And the seriousness here is a man was sent to the hospital. A man was injured to the point he needed surgery. And we're here 2 years later, and we're hearing nothing regarding regret. Given all of that, I am asking this council to find by preponderance of the evidence that George Johnson committed Category A and Category B unprofessional conduct and vote to permanently revoke his law enforcement certification. Thank you.
Thank you, Attorney Burkett. At this point, I believe that concludes the closing arguments of the attorneys.
Just a point of information regarding the time.
Yes.
Or do we have expectations of lunch, or should we move to conclude?
So that is an excellent question, which I was about to propose. So at the very minimum, I am going to need to take a bathroom break. So what I would like to suggest is this, that we take, and I'm asking if there are issues, especially around so actually let me back up for a second. Presuming that we get a motion to go into executive session, the only people that can go into executive session are the members of the council that were present for the duration of the first day's hearing. So that group, at a minimum, I'm asking to reconvene at exactly 12:40, which is a half an hour from now. Is there anybody that cannot do that? In that time, hopefully we can take bathroom breaks, grab a quick bite to eat, coffee, whatever, and reconvene. Is there anybody of the folks that were at the original hearing that are council members that cannot make that happen? Okay, seeing none.
Can we just declare a recess? Mr. Chair, I make a motion that we enter recess.
We have a motion to enter recess for 1/2 hour. We have a second to the motion to recess for 1/2 hour. All those in favor, please raise your hand and signify by saying aye.
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 Any opposed? All right, please promptly be back here at 12:40. Thank you. Lindsay to do a roll call.
Okay, if you could, if you are back, please turn on your camera and then confirm when I call your name, please. Leslie Johnson,
Yes.
Butch Shaw,
Here.
Wade Cochran,
Present.
Justin Stedman,
Here.
Heather Sankowitz,
Here.
Domenica Padula, sorry, was that you, Domenica? I'll come back. Aaron Hodges. Here. Tom Jeanette.
Here.
Mark Anderson,
Hello.
Jonathan Bixby,
Here.
Kate Proberg Gabab,
Yes, I'm here. Thank you.
Domenica Padula. Not see her on right this second.
How do we do? Are we quorum wise okay or no?
So quorum for the hearing is 9. We have 10 without Domenica. So we are okay.
Then with that, are there any motions to be made?
Mr. Chair,
Sir.
I move we enter executive session pursuant to one VSA 313A, one sub E, sub F, and one VSA 313A4 to discuss the matter at hand.
Excellent. Is there anybody besides the council members that you think should be?
Inviting Lindsay TheVerge and Wesley Lawrence.
Right. There is a motion to enter executive session inviting the council members who are present, or well, not inviting, but for the council members who are present at the original hearing, as well as Lindsay TheVerge and Wesley Lawrence. Is there a second to the motion? Seconded by Tom Jeanette. Is there any discussion on the motion? Hearing none, all those in favor, please signify by saying aye or raising your hand. Opposed? All right, Miss Lindsay, we'll give you a few minutes to set up a.
Okay.
So-
I'm actually gonna open up a breakout room. So I'm gonna open that now and that will pull everybody into that. I see Lynn Mulligan.
Hi, just a point of inquiry is in terms of how you would prefer that we wait in abeyance. So like, are we just meant to hang out by the computer and
Here, but we can
see you in a few hours, or?
Hopefully not a few hours, but yes, if you could maintain presence, we can text you when we're getting close to coming out or when we're gonna reconvene.
Perfect, and you'll come back to this room no matter what, so I'll
Correct.
hear you at least. Okay, great.
Sorry about that. Thank you.
Just gonna make sure everybody who's supposed to be in there actually gets it in there, so. Hey, Leslie, I see you are still here, so I'm gonna try this. And let me know if you're getting any sort of request to join the room.
I don't see anything, Lindsay.
Oh, see why I think I maybe had the wrong. Try this.
There we go.
Okay, I will see you shortly. We are coming back in from executive session. For those who are available, could you please, I should say council members and council, could you please turn on your cameras if you are present? I will be doing a roll call vote.
Can't say it, we've already gone past the point of time.
Okay, it looks like everybody's in, so I'm just gonna roll call those voting members so that we can initiate executive or initiate the public session. Sorry, Justin, I'll wait for you.
I'm all set. Sorry, my apologies.
Nope, okay, I just wanted to make sure you were good. Okay.
Yep.
Okay, Leslie Johnson,
Present.
Butch Shaw,
Yes.
Wade Cochran,
Present.
Justin Stedman,
Here.
Heather Sinkowitz.
Here.
Domenica Padula.
Here.
Aaron Hodges,
Here.
Tom Chinette,
Here.
Mark Anderson,
Here.
Jonathan Bixby,
Here.
and Kate Parlbrook Kabam.
Here.
Okay. Everyone is back.
Okay, we are back in the public meeting or the hearing on is the number 202-46B9. I'm looking for any potential motions.
Mr. Chair, I make the motion that we dismiss the category A offense.
All right, there is a motion on the table to dismiss the category A misconduct. Is there a second to the motion?
Second.
Motion has been moved and seconded. Is there any discussion? At this point, we'll take a roll call vote on dismissal of category A misconduct. You're muted, Lindsay.
Sorry. Vote yes or no for the dismissal of the category A. Leslie Johnson,
Yes.
Butch Shaw,
Yes.
Wade Cochran,
Yes.
Justin Stedman,
Yes.
Heather Sinkowitz,
Yes.
Domenica Padula,
Yes.
Aaron Hodges,
Yes.
Tom Chinette,
Yes.
Mark Anderson,
Yes.
Jonathan Bixby,
Yes.
and Kate Parlbrook Kabam.
Yes.
Unanimous, yes.
The motion for the dismissal of category A has carried. Are there any additional motions at this point?
Mr. Chair, I make a motion for category B, finding excessive use of force under authority of states, first offense.
All right, we have a motion for a finding of category B misconduct, use of force, first offense. Is there a second?
Second.
It has been seconded. Is there any discussion?
Sorry, who was the second?
Oh,
Anderson.
Mark Anderson.
Okay, thank you.
Hearing no further discussion, we'll have a roll call vote on that motion.
Leslie Johnson,
Yes.
Butch Shaw,
Yes.
Wade Cochran,
No.
Justin Stedman,
Yes.
Heather Sinkowitz,
Yes.
What is?
Domenica Padula,
Yes.
Vermont criminal justice.
Aaron Hodges,
Yes.
Tom Chinette,
Yes.
Mark Anderson,
Yes.
Jonathan Bixby,
Yes.
Kate Parlbrook Kabam.
Yes.
That is 10 yes, 1 no.
All right, the second motion has carried 10-1. Are there any additional motions?
Yes, Mr. Chair. I make a motion for a written warning with a recommendation for retraining around use of force and de-escalation.
We have a motion on the table for a written warning for the finding of category B misconduct with additional training as prescribed. Is there as laid out in the motion, is there a second to that motion?
I'll second.
Seconded by Aaron Hodges. We will do a roll call vote on the third motion.
Leslie Johnson,
Yes.
Butch Shaw,
No.
Wade Cochran,
Yes.
Justin Steadman,
Yes.
Heather Sinkowitz,
Yes.
Domenica Padula,
Yes.
Aaron Hodges,
Yes.
Tom Chinette,
Yes.
Mark Anderson,
No with explanation.
Jonathan Bixby,
Yes.
Kate Carlberg Cabone.
My mic's not working.
I hear you.
You can hear me?
Yes.
Great. No with explanation.
Eight yes, 3 no.
8 yes, 3 no. Okay. The motion at this point is carried, and I will turn to Mr. Anderson for explanation first.
Thank you, Mr. Chair. Current law does not provide the council with discretionary authority in a method that provides appropriate clarity and confidence to stakeholders, including the law enforcement profession, Sergeant Johnson, the St. Johnsbury Police Department, and the public. I believe this case provides opportunities for future statutory changes that can be made to improve the professional regulation systems. And I hope that we can use this case as an example for future improvements with the legislature.
Thank you, Mr. Anderson. I will turn to Miss Kate. I apologize. I'm not going to get your last name, so I'm going to just say Miss
That's
Kate.
okay. That's okay. Yeah, I don't have as well reasoned of an explanation as Sheriff Anderson. I just simply wasn't convinced that a written warning would be sufficient, given that the council found grounds for discipline on violating the use of force policy.
Thank you for that. At this point, I believe that concludes the hearing on this specific issue. With that, is there any member of the public who wishes to comment? Hearing none.
Mr. Chair, I make a motion, we table the rest of the day's agenda and adjourn.
Motion to table the rest of the agenda and adjourn. Is there a second?
Second.
Seconded by JJ. All those in favor signify by saying aye or raising hand. Opposed? Thank you all for the extended time here today. I wish you all the safe rest of your evening. Thank you. We are adjourned.
Thank you.